big names in Mumbai's or Pune's market are still trying and pitching for redevelopment, but the same big names are yet to deliver the project, which is running into delay for more than 3, 4, 5 years.
Have you seen sometimes committee members trying to influence the other members just because the developers probably bribed them?
After COVID, the rental market has become unpredictable in different pockets of city like Mumbai, even in Pune, even in Thane. People are finding more and more value for convenience.
In fact, I feel a redevelopment project going wrong is even worse than a normal project going wrong, because in a normal project at least you have your house, but here they've broken your existing house and then got it stuck.
The preference or the duty most of the times we cast in redevelopment agreement is that first the rehab component members will get possession.
Right.
Then the developer will offer it to free sale buyer. First, the owner of the structure who gave you the property will get the first opportunity to walk into the buildings.
For a developer's perspective, what according to you is a developer's biggest expense in a redevelopment project? Hi guys, I'm so excited for this episode of the Real Estate Show with Mayank, because today I have with me advocate Rahul Hingmire. He has a law firm across multiple cities in India, Mumbai, Pune, Delhi, Hyderabad, and he's going to talk to us majorly about redevelopment. Now guys, as you already know, in Mumbai, redevelopment is the present and the future of real estate. Mumbai real estate is all about redevelopment right now. In layman terms, redevelopment is essentially when you redevelop an old building, you break it down and build a newer building with a better construction quality and better amenities, right? But today we're going to talk to advocate Rahul Hingmire about the nuances, the mistakes housing societies and members make, and sometimes even the mistakes developers make while entering into a redevelopment project. So thank you so much, Rahul, for taking out time from your busy schedule and gracing us with your presence.
Thank you, Mayank, for having me here. I'm truly excited to see what questions you're going to throw at me and how I respond to it.
I'm sure you'll respond to them, all of them, with utmost knowledge and grace.
I'll try my best.
And that's why you are here with us. And thank you so much again, for taking out time from your schedule. Now, I'll just cut to the chase right now. Can you, in detail, right, step by step, tell us the entire redevelopment process of a housing society, of a cooperative housing society?
Sure. So for housing society to decide that their project is eligible for redevelopment, there are some checks and balances that they need to perform. For a housing society, it is important that whether their structure is sustainable or weak, or we call it typically in our technical terms dilapidated, which means it's not safe to occupy.
Right.
So for that understanding, they need to bring firstly a structural auditor. Society needs to conduct a meeting and they need to come to a decision that look, the building's parts visibly are showing or cracks, or they are not safe enough to occupy. You hear certain times slabs are falling, you see pillars and beams are showing visible cracks. In these scenarios, society members should pass a resolution to have a structural auditor appointed. BMC empanel structural auditor strongly recommended. That structural auditor will perform checks. They will do the tests. These are equipment they are provided with to perform tests on the pillars, on the beams, on the walls, to understand whether the structure is safe enough to just repair or it requires a demolition and reconstruction. If the structure auditor's report recommends that the building structure is beyond repairs, then the society member need to do next step. That is to decide that this building should go for redevelopment. For that, they need to take members' vote in general body meeting. 51% members who are attending the meeting with majority should say, 51% majority should go for a positive vote that yes, the time has arisen and we are left with no choice. Repairs are not possible and feasible for many reasons that structural auditor report would recommend. And for that purpose, we will start the process of redevelopment. Now, this step means the second part will be to get someone who will make society understand that the plot at which the building is standing, what kind of plot, what kind of development potential, we call it floor space index, but development potential to be simply put, it holds for any offer that society should make to developer or should receive ideally from developers to decide which is the best offer, what kind of costs are involved. So all those assessment calculation society members cannot do by themselves.
Right.
They need some expert. So project management consultants, civil engineers, architects, these are project management consultants, they need to called in for. Now at this juncture, society can take help of 79A directive principles, which is a protocol given under Cooperative Societies Act. For any time when society wants to go for redevelopment, society can follow the directive principle, which is a protocol in which first step is project management consultants appointment by way of putting a public notice, preferably in newspapers, and calling for their offers and tenders from project management consultant. After receiving multiple offers, understanding the prior experience of completing certain redevelopment project properly, understanding their knowledge about that area in which the plot is located, the ward, the corner, the city area, uh, societies should then take a very mindful decision that such project management consultant should be appointed or not, who fits to their bill, their budget, their expectations, their requirement and stuff like that. The presentation needs to be taken from the project management consultant for society to get convinced with the capability, the experience and know-how of that project management consultancy firm or individual. So let's say society has appointed a project management consultant, Mr. XYZ.
Right.
After Mr. XYZ getting appointed, as per the procedure, Mr. XYZ will perform the checks and balances on the development potential, on understanding the prior plan under which the building was developed, and will also try to see the available norms and schemes under which the redevelopment can be undertaken.
Right.
And basis of that, that project management consultant will design a proposed project scheme. In that, he will not get into very details of how the building should look or not like that, but he will come around a fact that this is the development potential in terms of square meters. In order to develop this kind of development potential for residential purpose, you will get this much of benefit. If you are having roads around your plots, what will be the mandatory setbacks that plot will suffer or plot will have to accept? What will be the development potential coming from that? If there are any schemes of FSI available because of the location of the plot, taking benefit of that. For taking benefit of FSI schemes, what kind of premiums will have to be paid? All that cost part, the project management consultant put it in its report, and we call that report feasibility report. Right. So he'll summarize all of it in such a way that society members can manage to understand the crux of it, to see to it that what is the total area that we can actually see getting built, how much society member are eligible for without any additional cost to be paid to developer under redevelopment schemes that are applicable to their plot, and what would be the surplus balance sellable area ideally in this scenario for a developer this plot consists. Once this feasibility report is drawn up, explained to society members and understood by everyone, then the next step would be for society members, either they themselves or through PMC, they can start drafting a tender document.
Right.
At this stage, society should also bring in a lawyer or a law firm which are well versed with cooperative societies laws, plus they are well versed with the land and real estate related development norms, laws, rules, regulations, and exposure and experience for other redevelopment projects. So therefore, a law firm or a lawyer which has handled redevelopment agreement transactions, society flat buying selling transaction, understanding what kind of rules, regulations and procedures society has to go through as per 79A for selection of a developer and completing a redevelopment project. So in this phase, introduction of lawyer will happen or law firm will happen along with project management consultant. Project management consultant and law firm or lawyer will then together finalize the tender document. What is this tender document? It's an invite to developers to submit their offer. But in that tender document, societies in consultation with project management consultant and law firm, they will create their minimum expectation chart,
Right.
what they expect from area, what they expect from amenities, what kind of legal terms and conditions they are having, which is non-negotiable, what kind of collateral or bank guarantees they are going to expect, what is the preference for society's rehab components they are expecting, what is the minimum expectation on parking. Many things will be laid down in the tender so that there is lesser negotiation or discussion on what is give and take that developer and society has to do after they start discussing offer. It is laid down beforehand only. So it's a self-explanatory tender document that is available for developers to come and pick. And for that, sometimes some societies are putting some cost also because they want bona fide interest only to come.
Absolutely.
It should not be like just because there is a tender available, random people, random developers should come and do it.
Absolutely.
So sometimes it's some thousands, sometimes there are some lakhs pertaining amount also that developers will have to come and put in society, which is non-refundable
Right.
as a tender purchase or subscription cost to go about it. For this, societies first will send out public notices again calling for society developers to submit some offers, or probably there are developers who are always aware about some redevelopment activities happening in certain areas that where they hold a great amount of interest or already some ready projects. Sometimes PMCs will also recommend societies some developers to approach, or sometimes societies approach some developers who have finished some project in their neighboring or neighborhood or near locations to go about. So in either circumstances, any of the circumstances, society collects some interest by way of developers subscribing to their tender and submitting their offer in response to that tender.
Right.
So
Typically, how many builders should be invited? Like, at least how many should you have before you can choose? You know,
ideally minimum three
minimum three.
developers. You need to see to it that what is the best case scenario that you can have. You cannot do that in one or two.
Of course.
You'll always see one better than the other. Three, but on an average, in a good location, good society, which has a good tender document floated, will receive good 5 to 6 interest as a minimum thing. Then there should be a discussion internal, not directly with developer. It should be an internal discussion with lawyer, PMC, and society to make sure that which are the offers are actually qualifying as per the tender document, which are the offers which are outside the scope of tender document or are not aligning with the expectation of society which were explained in the tender document. So those needs to be removed. And then the documents that the offers that given by the developers which are qualifying, then society can ask more details. Sometimes these details could be project reports, their projections, their financial capability part. They can ask the developers to submit more details on their past work done
Right.
in terms of recent completion to track record. Many things can be called in further for more clarity, more awareness, more information, so that society in their general body meeting, when they are going to take up all the offers and discuss it among the members to go about selecting one developer, they are well informed and their decisions are also well informed accordingly. And again, then majority with 51% will determine which is the best developer to go with. There are many advices and suggestions. Project management consultant, we as a lawyer, or some chartered accountants who will come in at some point in time where they need to see the financial projections, financial disclosures, financial arrangements that developer has made for this project. They will also test it, and their inputs will also help societies to decide the best developer to go about it. Up till this point, society is very much sitting on the development rights. Once they decide that they will go with A or B or C company, out of ABC they decide to go with A company. Once they decide, this A company and society will start exchanging the draft of development agreement. We
Right.
call it redevelopment agreement or development agreement, which will cover the whole project pertaining arrangement terms and condition. I'll get into details in some other question, but motamati development agreement will be something that will get floated, which will have a lot of clauses, obligations, reps and warranties, do's and don'ts, and disclaimers and disclosures on many levels. Uh, Cost part, amenities part, offering part, list of all the things, plus proposed plan of what developer is going to seek approval for. All that will come into the redevelopment agreement, and all
Right.
the termination clauses, many things will get captured in that redevelopment agreement. Along with that, the developer and society will also negotiate on power of attorney kind of a document, which society also needs to give at the initial point of redevelopment process, so that developer can take that power of attorney as an authority from society given to developer and start applying for all the procedural applications, approvals, permissions, sanctions across the multiple windows that developer has to go for seeking permission to start project. So these documents are critical documents. We also recommend that at this stage you also negotiate permanent alternate accommodation agreement also,
Right.
which is PAAA we call it normally, which is for rehab component members to have a new apartment pertaining promise from the developer to the individual member, not to the society only, to the individual member, saying that this Mr. A, B, C will get this and this apartment on this and this floor with this and this dimension, with this and this parking allotted to that apartment. So this is developer and individual rehab component member and society confirming that as an arrangement. This
Right.
PAAA agreement also needs to be exchanged ideally at this stage, so that development agreement, power of attorney, and PAAA, these three agreements gets negotiated. At conclusion on negotiation and finalizing the document, the developer and society will attend registrar's office to execute the first two documents, redevelopment agreement, power of attorney. Basis of this, the transaction is now structured and frozen between society and developer.
Right.
Up till this point, society is still in the society building. They are not giving possession. They are very much actively using their old premises. Once this redevelopment agreement is done, the appropriate stamp duty is paid to the government. Power of attorney is also registered, executed. Redevelopment is also registered, executed. With these two documents, now developer gets a good enough power and authority on behalf of society. He will start then approaching the municipal corporation or Mahada, depending on the owner of the plot, and will get the approvals.
Right.
Now, one of the key stages in the redevelopment agreement is always talked about is handing over of possession by the society members to developer, so that developer can actually start demolishing the building and start constructing a new building. That's a significant stage in the
Right.
redevelopment project. For that, many a times developer will defer the registration of power of permanent alternate accommodation agreement. There are good practical reasons for that, because while discussing the redevelopment agreement, there can be a version of plan A. Authorities may have some, suggestions. So there can be
Right.
some modification in the plans. And the final approved plan is something that we call IOD, intimation of disapproval. On that stage, the developer promises to society that as soon as I get this first approval, intimation of disapproval, we call it in usual term of real estate,
Right.
IOD plan,
IOD.
then I will ask you to vacate the premises and I will then start the construction, demolition, and then construction work to go about it. Around this stage, we strongly recommend that you should also attach that approved plan to your PAAA agreement and also get that PAAA agreement signed, registered, stamp duty paid, executed, everything, and then only you vacate the premises. This is an ideal scenario. Once this is done, then the developer gets the hold of the project. Some of the redevelopment agreement will say developer will have only license to enter into premises and the possession will always be there with the societies. Some of the redevelopment agreements will be very clear that developer will be given possession of the land and the building, and developer will be entitled to demolish it after everyone vacating and after developer getting IOD.
Right.
And developer start paying transit rent part to go about it. So developer starts paying the rent, which is a hardship compensation, transit rent compensation part, and possession is received by developer of the old tenements. Members vacate, members move into different premises, whole building is emptied, developers start demolishing it, and developers start taking permissions after permissions for stage to stage. So first IOD, then commencement certificate, then revised extended commencement certificate,
Right.
and construction permissions for floor-wise scenario. At this point, project management consultant appointed by the society will start monitoring the project. So he'll make periodic visits. Ideally, his 2 or 3 persons should be stationed at the project to see to it that anything that is happening on the construction site is as per the promises that are made under redevelopment agreement. All the materials are coming as per the same qualities that were promised. All the materials which are reaching the site are also utilized in the actually supposed timeline. so that it doesn't lose its quality and strength pertaining elements to go about it. We always see that cement is such a critical component of the
Right.
construction work, but cements, after it being released from mixers, it has to be ideally utilized in 3 hours time,
Right.
and sometimes it stays on the project site for 6 hours.
Right.
That means it has started losing its quality, which will affect the sustainability and structure strength to go about it. So all these things PMC's personals, office representatives should observe and report to PMC, and PMC also should make periodic visit to see to it that whether the construction work is happening at the pace that was promised in the redevelopment agreement. Are we achieving and are we having sufficient time to finish the project as per the timeline that developer had proposed? If everything continues to work as per the redevelopment agreement, the developer will continue to get permissions, and it will reach to a point where developer will also start closing for the occupation certificate. So he will have all the fire approvals, all the BMC visits, all the necessary authorities to come and visit the project to get to a point where he will be eligible to receive occupation certificate. I'm talking about ideal scenario,
Right.
Mayank, here.
Very without
Everything
delay.
without
Yeah.
delaying, without talking about
Right.
all the ifs and buts and
And
the
the 100 things that can go
drama
wrong.
that goes into this.
Right.
And once the OC is received, then the first thing, the preference or the duty most of the times we cast in redevelopment agreement is that first the rehab component members will get possession.
Right.
Then the developer will offer it to free sale buyer. First, the owner of the structure who gave you the property will get the first opportunity to walk into the buildings,
Right.
and then the free sale will come. Once this is achieved, most of the times we think this is it. Flat members have got possession, tenants have, rehab components have got possession.
Right.
That is end of the redevelopment project. Unfortunately, it is not. That is only one provisional arrangement that is made where now members can safely go and occupy the premises, be it free sale buyers or rehab components. There are some more formalities and approvals and permissions that developers still have to go about doing it. Then they are actually eligible to get building completion certificate, BCC.
Right.
That is the end point of construction activity. And thereafter, the developer who has been maintaining the site, administrating the whole development, managing it with his manpower and facility management and maintenance team and all, then at some point in time, developer has to hand over all that along with the amounts that developer had collected from the free sale buyer as a maintenance contribution. Developer had allotted some corpus component towards maintenance contribution. All that he has to hand over to the society's managing committee, and also he has to hand over the details of the accounts as to how he has utilized the maintenance fund that he had collected from the free sale buyer till the time he was managing it on himself.
Right.
At this point, we actually call it completion of redevelopment project in ideal scenario.
In ideal scenario.
Yes.
Very well explained. Right. I think you went through all the steps with, utmost clarity. Okay, now my next question to you is conveyance. What should a society do if they don't even have conveyance of the land?
Mayank, I need to add one aspect on meaning of conveyance first, because
Right.
there is a lot of confusion that we observe
Right.
when society gets to hear this word conveyance, and they have some misunderstanding or misconception. In simpliciter means, conveyance means ownership of your land on which the building is standing, including its parking and amenities and everything.
Right.
Okay. Now, suppose you don't have ownership of land. In what capacity you can determine the future of that land? How do you decide who will develop, who will be the developer, who will be PMC? So, I have said this many times. If you don't have conveyance, that is the ownership of the land, any discussion on redevelopment is just waste of time.
Waste of time.
You're doing futile exercise, you're spending money unnecessarily on your project management consultant and your lawyers or any architect or chartered accountants that you will hire. I strongly recommend members who are in this scenario is to start taking steps to get that ownership.
Right.
And you are rightfully entitled under Cooperative Societies Act with amendments under deemed conveyance provisions. You are very much clearly eligible and entitled if you are having a cooperative housing society registered on that piece of land, and if you are owning that building, the land also rightfully should belong to you. For that simple steps, either you call upon the developer who had developed the land, who happens to be owner, to convey it to you. If there is a different landowner, you call upon that landowner to convey the land to you. If these two parties are not responding, then you take them to the deputy registrar's office under Cooperative Societies Act for under deemed conveyance application. Procedure is self-explanatory, very much easy to understand, and completed within 6 months to 12 months time frame. Plus, we have seen recent notification also that deemed conveyance application should not be stretched beyond reasonable time frame. Otherwise, for the delay, the deputy registrar will have to explain what caused the delay for his decision making process. So conveyance is a at most needed first thing on the list for society even start thinking,
How do you
talking
redevelop something you don't
about
own?
redevelopment.
Yeah.
Yes, absolutely. You summed it up pretty well.
So now tell me, have you seen scenarios where the society doesn't have the deemed conveyance and the building is fallen down? What happens then?
Societies have to take steps, and at a times they will have to do it on urgent basis. Otherwise, the scenario that you narrated, in that scenario, members who were staying before that, scenario, and let's talk extreme scenario. What if it actually collapses?
Yeah,
Their ownership has gone.
gone.
The landowner remains landowner. Now you don't have protection of Cooperative Societies Act to talk about your past apartment which was standing. And unfortunately, in Mumbai kind of cities, we have seen some sad, very unfortunate, tragic examples also of this nature. In Borivali, I believe some building got collapsed, and members are nowhere to go now. They don't have any scope for asking for ownership of the land, because the time that they had when the building was standing and their cooperative society was registered and existing, that was a time to seek conveyance. But if the structure is no longer being occupied by your cooperative society, then you cannot seek anything for the past structure.
Absolutely.
So they'll be in a very unfortunate scenario, and not any claim that they can put on that land for any kind of development or redevelopment to talk about.
Right.
See, redevelopment means something to reconstruct.
Correct.
Ultimately, there is
Correct.
nothing left on the structure.
So
So what do you
what
call
you're
redevelop then?
Yeah. That's a very sad state of affairs that society should, I think, irrespectively do it.
And it's a
Why,
cost-wise
why
very
wait?
cost-wise it's very normal. Procedure-wise very self-explanatory. I would say it will be mostly in the society's favor if the society has registered itself, have proper documents, all the members' records are maintained properly, all the necessary dues are cleared properly, and the adjudication order that comes for society to pay off certain fees to complete the deemed conveyance. I think it's the basic thing that society must gather and do it on the priority. If anyone who is watching this video and any society members who is contemplating should we go for deemed conveyance or not, I will strongly recommend drop everything that you're doing, stop
just
everything
do
that
this
you're
first.
thinking, do this first and foremost thing. Go and register for that application in the process, because that's the most critical thing you will always be reminded about in case you are talking to anyone of redevelopment, or if your building is in dilapidated condition.
Right. Now, a lot of buildings in Mumbai are built on leasehold land, right? Especially South Mumbai is full leasehold land. When it comes to redevelopment of those structures, right, is there additional red tape and excessive bureaucratic delays in that? How would you go about that?
Now, leasehold lands come with a different arrangement than the ownership. Lease means you are given a temporary possession, but
Right.
possession is an important word. You are in valid possession. That lease period, that temporary period could be few years, or it could be 99 years, it could be 200-300 years. There are so many properties on Marine Drive, so many properties
Absolutely.
between South Bombay to Sion area we can see, or Mahim area we can see, they are on leasehold arrangement. So your lease rights, what it said when the lease deed was executed, whether this lease agreement and rights are also coupled with the development of that plot for future scenario, is that development happening with or without consent of the landowner, which most of the times is government, state of Maharashtra, then you have to also pay the necessary premium for such development. Or if you want to move it from the leasehold land to ownership land, then you will also have to go about applying for the necessary change in ownerships, change in the
To class
classification
one.
of land to class 1 to go about. So awareness, knowledge, readiness, contribution timely for all those things are much needed to deal with these problems. Otherwise, any society which is dealing with leasehold land pertaining proposed redevelopment project, they need to have a good consultant who will make them understand what they are entering into. I have seen situations, Mayank, where societies are not aware about the legalities and technical procedure that are attached,
Right.
which you also put in your question, the bureaucratic, procedures and hurdles and the demands and the delays and the many over the table or under the table scenarios that they have to be ready to deal with. And they submit all of this as a problem to some developer. Sometimes these developers will give promises and hopes that don't worry, this is the usual process we are dealing with on these things day in day out. But the same developers at a times will keep that problem on hold till the time his other things,
Things are
other
sorted out.
equations are not falling into place.
Correct.
Now, you are saying you are into a problem. You're giving that problem to someone who is going to become a problem solver for you for a larger project
Right.
or larger situation. Sometimes you are making a wrong decision. You're taking a wrong step here. You have to solve your own problems. Converting into C1 or taking deemed conveyance order is your responsibility, not
Right.
some developer's responsibility who was only supposed to come and redevelop the project.
Right.
And if you give all of this to some developer, good ones will solve it, but those who are having different intentions, they may misuse that as a problem in their favor
To delay.
and they'll block the project, they'll keep it stuck and they'll always give you this explanation.
Correct.
आपने तो convince नहीं दिया
And
था, आपने
delaying
तो
is so
ownership नहीं था.
profitable for him eventually.
Every day,
Yeah.
every quarter, every new financial year or every new change in policy can add few things for
Yes.
them and they
Especially
can benefit.
delay before execution starts is profitable for him.
Yes.
Right?
And those same developers may sell this project in some different way.
Right.
They may start discussing this in their circle to find someone else to come and buy it at a different price.
Right.
Society will not get to know also about all these things.
Tell me how important is the structural audit, right? You've spoken about that when you were defining each step, right? Step by step. Say the society, when you declare as a C1 structure, as a dilapidated structure, but say the society, irrespective of the structural audit, wants to redevelop it anyways. It's not dilapidated. It's okay. We don't even need, perhaps we need minor repairs, right? But we just want a newer building, right? In that case, what does the society do and what is the process?
So these situations will always come for societies which are strong, well maintained,
Right.
but they know that they are sitting with on a very large scale of development potential.
Right.
Probably a lot of things have changed around them, and that everyday
You want to
exposure
take
to
advantage
them.
of the increased
Yes,
FSI or,
yes. People want to, accumulate wealth also in that form. People want to generate some profits for them, so
Sure.
they will go for this. If the building is under 30 years time or a building is sustainable in nature, not declared as a dangerous dilapidated structure by any reports or any structural auditor's report, then the society members have to be 100% on board.
100%.
Yes, that means it's 100% consent that is required.
So even one person can stall it.
Absolutely. If the structure is not beyond 30 years and it is fit structure which can be taken care with minor repairs, he can install it. And we have seen enough examples also in High Court where people have decided to go for redevelopment and with the proper correct reports which are suggesting that it is very much good structure to continue to use and it is a structure which can be managed with some minor repairs, doesn't pose any threat to anybody's life or kind of causes any danger. For those things, some members will become a spoke in the wheel for larger members' interest. And you need to understand why they are doing that. Because these sub members may have invested 20-30 lakhs in renovations recently.
Fair enough.
These people may be having some senior citizens in their family and they don't know at that age of their life, stage and age of their senior members, family members' life, they want to make them relocate into some different place.
No, it is absolutely the right
Yes.
to reject. I mean,
Yes, the reasoning is also important. How do you get them on board? If majority still wants to go for redevelopment, what is the provision that you are making for them? I'm not talking only from the money point of view. I also strongly recommend societies to get together to understand those who are objecting. What is the fundamental reason to object? Are they only talking technical, but are they also having some internal challenge that is causing them to take advantage of this technical thing?
Right.
Because if at all everyone agrees to it, then benefit will also be passed to everyone. Is this benefit a lesser benefit compared to staying in the property for them?
Absolutely.
That assessment can also make societies understand how to deal with this minority who is objecting in a safe and strong structure pertaining proposed redevelopment scenario.
Now let's assume the building is more than 30 years old. More than 30, but not dilapidated. Right? In fact, it doesn't even need minor repairs. Right? In that case, can one society member stall the entire redevelopment project?
He can put good questions, he can put good alternatives, but after 30 years, majority can rule, 51% can decide that this is a good time for us to go about taking the newer rules pertaining FSI benefit, development potential benefit schemes that are available, and that will be in the interest of all the occupants who are occupying the premises to go about. I strongly feel in this scenarios, very few building will be strong and stable for next 20-30 years. You might be looking at a period of 5-10 years, but technically the civil structures that are built in last 50 years, they're having life up to 40 or 50 years only. And if that too not maintained properly, then you're talking about scenario which can expose certain unwanted situations or bring some tragic situations or scenarios or mishaps that only people will realize after experiencing it. So if it's beyond
the
30,
minority in such a case, either the free feel to they can sell their flat and move out, or they have to then just go with
selling of apartment before signing redevelopment at any point in time, they can go about doing it before consent affidavits that society members give in favor of developers. And we see many
or then
times
they go ahead with the redevelopment.
redevelopment
But
project.
they can stall it, you feel, for a certain time at least.
For
Beyond 30 years, not dilapidated.
Beyond 30 years, not dilapidated. Objection wise, we have seen many objection, but stalling wise, majority rules the call, and majority will take it ahead accordingly.
Right. On a more philosophical note, not about redevelopment, I'd just gone to Lucknow and I'd seen Imam Bada. It was built, just like Taj Mahal, it was built 400 years ago. Very on a philosophical note, right? Imam Bada was, I think, about built 280 or 300 years ago, and it's still standing so strong. Of course, different architecture, not that tall, of course. Stone, right? Your half of fort is still standing strong, and that's why sometimes I feel like it's been 30 years. Ideally, your concrete structures should be, more long lasting, at least 70 years. That's what I feel. It's just a philosophical thinking. But I think now design sensibilities have changed. Architecture has somewhat been diluted by data, speed, project feasibility, and profits.
The last part.
Yeah. Profits. Keyword being profits. And I feel like with all this newer technology, the construction quality should have improved. But when you're forced to kind of see major repairs in concrete structures in just 30 years, it brings me to my next thought that look, the older structures without technology are still standing strong.
Yes. I completely agree. We always get to hear British era bridges, Victoria Terminal, which is CST now, or BMC building, or
With
some
all
colleges.
the artwork and detail,
everything.
Every door, pillar, wall had a story to tell you.
So there was no end game of the architect who was trying to make profit only out of that premises, and there was no seller or buyer equation.
Right.
It was done for the country or the government or the ruler or
With
the
utmost quality.
Yes,
the pyramids are still standing.
Yes,
to talk about.
Because the consequence was come back again, do it, or probably in pyramids time some different consequences. But here it was a very different calling for those architects, and it's not only 200-300 years ago. I'm saying probably some university, some colleges, some hospitals, some public infrastructure that gets developed. In fact, the other day, one of my very dear friend, and I consider him as a mentor, Sandeep Sakpal sir, he is a renowned project management consultant. He shared his experience when he visited Gujarat after the earthquake scenario. The only structures were standing strong were government buildings
Because they were built.
for government
Yeah.
without any cutting of corners, without any focus on profitability. It was always given by government for contract basis with utmost clear quality being the topmost priority.
Right.
I remember I have school, college in my family run education society also. I see thin walls of 18 and 9 centimeters. Uh, we have built 36 centimeters width walls. And I was asking why so thick walls when we've seen in apartments small walls. This was when I was in my 12th standard, I believe. And my family's response, my mother's response was, we are not building it just for now. We need it to sustain the future structures that we'll be putting it
Absolutely.
and all the things that it's going to face for next 30, 40, 50, 60, 70 years. We don't know for how many years this has to go. So we are not thinking about cutting corners here. That is the same approach. Most of the construction activities that were done for a good cause or with better, flexibility being given and liberty was given to the constructor, civil engineer and architect. Uh, Charles Correa, the renowned
Yes,
architect,
yes.
his structures I have seen, and some of his students are of my good friends, best friends. We talk about what was the cause, what was the thought process, what was the planning, what is the liberty that is given to the architects. Budget was one of the situation, but it wasn't the key determining factor all the
Quality
time.
was so important. Now I think it's profits. And in fact, I was just when you drive across Mumbai, I definitely think this is going to be an urban challenge. Let's not talk about redevelopment for just 2 minutes, right? When you talk about SRA, which is also redeveloping a slum, if you see those rehab buildings, they are beyond pathetic. And I feel they might just need those rehab buildings per se
Hmm.
might just need redevelopment in 10 years. There's no policy for that. And it's going to be such an urban challenge because you've made a slum land technically more dense now, right? Because you've got the rehab structure, plus you have the sale component as well. But the rehab structure is wearing and tearing in less than 4 5 years. So let's see what happens in the next 20 30 years. It'll be a
It's a
and developing
problem.
an SRA rehab which is 20 floors. It's going to be I think an urban challenge that Mumbai will see in the next 20 years as those rehab buildings start giving way. It'll be very interesting.
It's a scenario that we all have to also understand why such hasty and not so strong quality construction, because in SRA projects developers are first given a task to rehouse
The
the
slum,
slums,
correct.
then only you will get access to the land which they will put up structure.
Right,
And some of the LOIs, letter of intent, will come with conditions that first you not only rehouse them temporary but also with permanent structures.
right,
And then you carve out that as a different plot. You put some boundary walls, and then your new free sale, free of slum dwellers structure on different corner or different side of the plot to go about it. As you rightly said, the not only the structure, by looking at it, if you compare that with the new structure, zameen asman ka farak that we can call it.
absolutely.
And no wonder because of which a lot of SRA project gets stuck, because these things get questioned by even the approving authority in SRA also many a times when they look at the state of the construction for the rehab component. Many a times the shortfall in area, many a times the construction quality, many a times the post completion approval also puts a big question mark. Then regularization, then improvement of the structure while it's standing, then strengthening the pillars that were constructed while the building is still standing, they are further expanded, strengthened more.
Right,
Adding more adjustments on the building is common feature that adds more cost to
right.
developer. So if you do construction in one go with proper intent, you will spend probably some more amount than what you would have done with shortcuts. But if you are improving a structure which is already standing, that is double cost almost.
Absolutely. Absolutely.
So SRA projects, I believe now with more stringent rules and regulations under Act and under the schemes, the quality criteria is being put in a top priority for all sites, not only for the free sale component. And lot of undertakings and responsibilities are casted upon developers.
Right.
And probably that will also determine whether they are eligible for the next project or not also.
Right.
A lot of things will come on that side.
Yeah, let's hope
Yes.
Mumbai is built now, will be built on redevelopment, the new Mumbai, I would say.
And the biggest SRA scheme,
We all know that.
that will be the guiding
That will be,
example. I hope that
I
it should
hope.
be the
Yes.
scenario that Dharavi slum rehab
I think
becomes
they
a
are going to
model.
Mulund now. So the
Yes.
Mulund will see an influx of, I think,
Some part of it.
yeah.
Some part of it is very much getting rebuilt there on Dharavi's portions.
Right.
Industrial and working businesses that were there in leather to many manufacturing to small businesses, they are also going to get rehoused there itself. Some part will definitely get displaced, but significant part of current slum dwellers of Dharavi have a plan to get rehoused on the same layout,
Right.
not not horizontal, vertical, but yes, very much there. And I strongly feel if it is executed well in public-private partnership model that
Or
government
public,
yeah.
we can call it public. Anyways, jokes
So
apart.
that
yeah.
model can be a guiding principle for many of the other slum redevelopment, because that can set a good benchmark and some good combination of not only leaving it to private developer to develop entire thing.
Right.
Having government officer as a CEO to monitor it, to look at it,
It's-
is also a very good way to go about. The
it's
public-private
gotta be a-
partnership agreement
Right.
that has been put in test with the biggest project that can change the skyline and the value proposition of that entire area for Mumbai, which will be the new heart of Mumbai if that is done
Going to
properly.
be a Herculean task, but if executed well, it'll change Mumbai. It'll absolutely change Mumbai, I feel. Now, getting back to redevelopment of housing societies, right? How does a society, how should rather a housing society select the right PMC? Some PMC that is always rooting for the society and neutral, at least let's call him neutral.
Neutral is a very unsatisfactory word for me. It has to be through and through in favor of society. That kind of
True.
PMC you need to have. Basic eligibility criteria I always see good societies doing or following while selecting a PMC is prior experience, completion of number of projects, know-how of their local area where the building is standing, understanding whether in that area the PMC has done any work or not. If you're in Dadar, you don't want a PMC who has done only projects in Thane. That's a different locality. This is different.
Hyper-local as well.
Yes, different DCPR application will come in, different rules of BMC will come in, approval processes will come in. So you need to have someone who has seen, done, and executed and completed projects in the same locality, same area that your society is located. Good knowledge of what is happening as per the current DCPR, as per the prevailing laws, as per the norms and scheme under which the plot is falling. He should also be very good in planning and estimating the project report in the form of feasibility. So you should ask for some sample of reports that were drawn up earlier.
Right.
And make sure you understand the angle that he applies or she applies when she or he is drawing up the feasibility report. His initial questioning and understanding that what all documents the society will have to provide to that PMC will also be a determining factor to know whether this PMC is going to go into necessary depth to quantify the potential that is up for offer for developer to come and take it as a redevelopment scenario to go about it. And the approach that PMCs should be having, PMC should make this as a two-phase project to go about it, should be transparent on their fee structure. Phase 1 is to get the feasibility report. Phase 2 is kickstart the redevelopment project as and when the developer is around to start working on the redevelopment project activity from a monitoring point of view.
Right.
My fellow PMC friends always say that feasibility report, drawing up a feasibility report, studying society's data, plans and prior histories, very insignificant part of his mandate compared to what he or she will end up doing when the actual redevelopment starts.
So the execution is definitely more.
So someone who has actually seen and lived through multiple execution is the right way.
Very well said.
To select a good PMC, and transparency on fee structure and willingness and readiness to take that fees only from society. is the most important criteria. You don't want developers to pay your PMC directly.
Right.
The money should be dispatched, delivered, transferred, remitted from society side to PMC from time to time, and there should be very clear, quantifiable, measurable KRAs and KPIs that should be very maintained in your PMC appointment agreement. And if needed, in a scenario where you think you will have to have a right to terminate that PMC, conversations of that nature should happen beforehand. Under what circumstances PMC will be terminated if certain A, B, C, D kind of things are observed. So all that should be there in your PMC appointment agreement also, or MOU also, to go about it.
Right.
It's a very important appointment, Mayank. That's why 79A protocol gives a very express direction for appointment of a PMC by way of a calling of tender, by way of a issuing a public notice and calling tender from PMC. That is not for lawyers.
Right.
But for PMC, it's very important, because I personally feel PMC is the brain that society is going to rely upon majority of time when they are living that redevelopment project as receiver of the benefit the developer is going to start working for. And if that person is not there with you,
No, absolutely.
then you will not
Such
get
an
to see.
important appointment. So with technical expertise and ethical as well.
Yes.
And tell me, how important is a lawyer and a CA for a society?
A society which is going under redevelopment, they need to have lawyer with prior experience of handling real estate matters, because redevelopment is all about determining development rights and lot of situations that have to deal with. And also a lawyer or a law firm which is handle cooperative court or cooperative acts, Maharashtra cooperative acts pertaining
Right.
advisory and litigation work, because you're dealing with a lot of compliance that society has to undertake under 79A protocol. You're also going to lead a lot of conversations on behalf of society with counterparties, that is developers, lawyers. You're going to negotiate on a lot of documents. So you need to have that imagination power to see where all things can go south. And for that, you need to have a counter mechanism which will benefit or protect society in all possible scenarios to go about it. You also need to have visibility on part where what all things society should give under power of attorney to the developer to complete the project, and developers should not struggle to get NOCs and approvals and permissions of societies from time to time. But also the power of attorney should not be extra large for developers to take key decisions on its own.
Right.
It should also take society's consent or inputs on something where plans are changing, building is redesigned or reshaping, or some external factors are changing the layout or causing some kind of inclusion of some government quota or components of apartments coming in societies, or reducing the parking or increasing the structures use in some way which is not as per the initial promise that was given by developer under redevelopment agreement to society. So all these readings, negotiations, finalizing the documents, and making society understand what this means. For that, you need a good lawyer or law firm setup. Now, I am from law firm setups, so I'd recommend law firm setups, because having one lawyer for a entire 3-4 years of project, sometimes unavailability of that lawyer can become a challenge for society members, which are always more than 10-15 members. Many a times it's 70-80 member society. So each one of them, or many a times involvement of a more than one legal mind can always generate more and more productive outcome. Having said that, there are some good individual lawyers also who have done fantastic work. So no disrespect to them, but more the merrier kind of thing can
Correct,
work in
correct.
complex transaction of redevelopment. This is about lawyer who will positively protect you in documentation, and in a scenario where the same lawyer or law firm will also protect your interest by taking legal steps to counter or to tackle the breaches that developer is performing or causing, or doing it intentionally or unintentionally, or putting the burden on society for some of his mistakes or some of the change in law and policies that originally he was supposed to take burden on his or its shoulder to go about. So lawyers can also come to correct the course
Right, of course.
when developer is deviating from the decided course for redevelopment. So these important roles lawyers will play till the completion of the project. And for chartered accountants, it is not something that every society thinks of or gets advice of, but I strongly recommend to involve chartered accountants right from the time society gets the details of project with finance angle attached to it from developer. Society should also open up its own financial positions and expenses pertaining arrangements right from starting the redevelopment project
Right.
pertaining activity, for it to have a proper audit system for all the cross checks, so that when there are committees changing during the transition period also, it is not left to a set of committee members who were driving the redevelopment and new committee members are clueless about things. That same chartered accountant will also help them in understanding how earlier funds were utilized when they were appointing project management consultant, law firm, or they were undertaking some services of structure auditor, what kind of expenses were incurred, why it is required. All those explanations and reportings will help them. Secondly, when they go beyond the appointment stage of developer, the same CA will also audit the inflow of compensations and transit rent that is coming to society from developer side, or it is directly going to members from developer side. He will also keep account of that, so that he can track and give time to time reporting to society members and managing committee as to where are we in terms of the financial commitment and compliance of redevelopment agreement as well. That becomes a very clear arrangement, so that no member is held accountable for some miscalculation or not maintaining
That is
account
so
properly.
important, actually. I think
Critical,
it's so
critical
important.
disputes will arise on that.
Absolutely.
Sometimes
It's strange then some societies don't have CAs. That's so strange.
they just see it as a cost, but
My
this
God.
cost can bring peace of mind and avoid misunderstandings. Some society members have got some benefit before uh, handing over possession of the apartment, and then there is some change in uh, payment structures that were mentioned in the redevelopment agreement, and because of which they may get less compensation in subsequent months of redevelopment period, but they put some blame on the managing committee who are misusing funds. Sometimes this is lack of knowledge and awareness about what they got into can also trigger these things. But that's where lawyer and CS can clarify things. CS can give accounts, they can give clarity, they can also demand more clearer accounts from developers who cannot play with the calculations and just give something to society to be happy with. And ultimately developers financial position is also something that we need to monitor. If developer is filing taxes or not timely, if developer is
So
dealing
crucial.
with some unpleasant insolvency proceedings, if developer is dragged into some litigation which is suspending its operations, if developer internally is having management disputes because of which management is not able to take any positive decisions towards ongoing projects, the commercial impact of that, liabilities of that. So a lot of things lawyer and CS can solve as a puzzle together and help society to navigate these challenging situations that they may not be hoping to encounter in their redevelopment journey. So I think project management consultant, lawyer or law firm, and chartered accountant can make a great deal of difference if they are appointed by society without being influenced by developer, and if society is maintaining their promises towards their payment, timely payment to these professionals. These professionals can be the actual defense mechanism to deal with before, during, and after scenarios that society was not hoping to face as a challenge from redevelopment or developers side. And that this mechanism can also help society to achieve its core objective of getting timely possession with quality and amenities that were promised under redevelopment agreement without losing anything
Right.
in terms of corpus, compensation, or
And it's just
receivables.
been a more organized and structured
Absolutely,
manner.
absolutely.
Now, you had spoken about the floating the tender document to invite developers, right? Typically, can you tell me in detail what should be the certain do's and don'ts of a tender document? What all clauses, what all things should be in a tender document?
Disclosures, I would like to start with. Disclosures about the project potential should be absolute in nature. Nothing should be ambiguous in nature from point of view of placing what it involves as a project, with kind of development potential, with kind of existing structure, existing number of members, expectations pertaining disclosure also should be very straightforward. Clarifying what is negotiable, what is non-negotiable also is very important. Putting very clear eligibility criteria to determine whether a developer with or without prior experience of putting up certain projects is eligible or not. Also clarifying that how many such project developers should have done. Also putting to the developer that developer should also bring completion certificate or occupation certificates as a conclusion points of such projects with the submissions of those bids to go about it. Understanding the financial health of the developer, you can call for some reports of the chartered accountant of the developer to give certificate as to whether they are compliant with all the compliances and taxes and dues that they are supposed to pay as a company from time to time. Getting all the information about their operations, about their finances, about their track record, and putting this as a clear thing for submission of information should be there. Making it abundantly clear that any deposit that their developer is doing towards buying or subscribing the tender document is non-refundable. Making it absolutely clear the process that the society is going to undertake, that it will not be only taking some tender that are received by so and so date. It will be a proper, well calculated and well assessed method in which comparison of all the offer will be happening, and thereafter it will be a majority decision to go with. Society should also make sure that developers are called upon to give presentations on the project part also, so that indication should be very much there as to what happens when they decide to select few and move ahead for further final selection process. What is it that they are going to expect after submission in response to the tender and before selection also? That procedure part and that process and steps involved part also should be explained to the developer in the tender document. Societies sometimes make mistakes of accepting some offer and developer construing it as an agreement also before entering into a proper redevelopment agreement. Society should also give appropriate disclaimers in the tender document indicating that what it means as an offer accepted, when it will be construed as an offer accepted, what the process in which they are exchanging offer would not mean as an offer accepted till the time they don't sign redevelopment agreement or till the time they don't receive some compensation or corpus part to go about it. Tender document also should explain in detail about the layouts, technical specification as per the municipal corporation's allotment, DCPR provisions, what kind of permissions, what kind of prior history of litigations, what kind of charges or loans or dues and payables that are there, if at all there any, about the society, and which society expects developer to take over that as a problem or responsibility to deal with. So utmost disclosure in all 360-degree, and laying out all the expectations which are easy to understand, quantify, measurable, should be provided in the tender document. And this tender document should be created by project management consultant, and legal terms and condition and financial terms and condition ideally should be also accepted by the lawyer and chartered accountants if it is involving any aspect. And bank guarantee part or collateral deposit part also needs to come in very expressly in the tender document, because this gets negotiated again and again.
Absolutely.
And I think with these kind of fundamental uh, grid rails, if they are installed in your tender document, you will filter out a lot of developers who don't have either means to do this project or not having honest and clear intentions to do this project. And the only developers will come through are seasoned, expert, with good intention and good financial, health and backing will only come forward, and then the subsequent process will be simpler and easy for society to go about.
Right now, at what point would you talk to the developer about the feasibility, right, and the additional area that you expect?
In the tender document, you attach the feasibility also, and you mention everything as to what do you expect over and above what members are having.
Which then can be negotiated.
Yes. It is always developers' side which will try to sweeten that deal. So,
To, of course.
what is minimum expected versus what more that developer can offer in response to the tender will be the determining factor. Suppose I am society and I am saying I currently have 1,000 square feet as a apartment size. Post redevelopment, I expect minimum 1,500 as a outcome for this and some XYZ amount of corpus in my hand. You are developer, you know that this is a minimum expectation and you're keen to take up this project. You will probably offer me more than 1,500. You will make it 1,800, and you may also give me more corpus, or you may offer me more corpus and same or less area, and justification also that due to feasibility I may not create more sellable, but I'll compensate you in the form of money to go about it. So there
Right.
can be different ways to come around this expectation part to go up.
Right. Now, what are some of the big mistakes housing societies make while shortlisting a developer for redeveloping the building?
By simply going with the offer,
Thank
they
God.
get mesmerized by some of the fancy presentations.
Additional area which is just inflated feasibility, which will never, it can't see light of
Practically,
day. Yeah.
yes. Areas, glossy presentations, whole shosha they will do while taking society members with a car or bus to some five-star hotel for the presentation. And some developers may not do all that. They will just simply call them to their office, getting impressed by all the other things which are not relevant or critical, not to take it on ego side of things or not to find it very attractive thing, but understanding which is the closest offer and most realistic offer that a project can have for
Right.
them. Prior experience, overlooking not having prior experience just because there's a good offer is also big red flag. Understanding whether developer's financial health is in his control or not. If a
So
developer is
critical.
dealing with multiple disputes, litigations, although they have a completion record, but they are still right now in disputes. If their current buyers are fighting for delayed period pertaining disputes in RERA, it's a red flag. Overlooking all those things is a red flag. Big names in Mumbai's or Pune's market are still trying and pitching for redevelopment, but they the same big names are yet to deliver the project, which is running into delay for more than 3, 4, 5 years. So if there is a track record history of this nature, and in comparison you are trying to weigh that with the very attractive offer, I would always recommend look at the past and then take a calculated call. You don't want to become the member of those litigated parties again with the same developer.
Absolutely. Now, for all the society members wanting to redevelop their buildings, please note that all that glitters is not gold, and also understand when it becomes too good to be true.
Absolutely.
Because then it's kauba biryani and then it stops being chicken biryani.
Absolutely,
So
absolutely. And
I
then you will
think
never see a single brick being laid out after you vacate.
absolutely, I
In
think greed
something.
works badly on both sides, the developer side and also the society member side
Very
as well.
true. Very
Greed
true.
is, it just never destroys a project,
Yes.
right? Now, what should be the ideal voting procedure for a developer? Once
For
they've shortlisted, okay, this is the offer we want to go ahead. What is the actual voting procedure for that developer?
this procedure you can find in 79A Directive Principle
Right.
that is provided under Cooperative Societies Act. The regulation recommends and endorses, and I also see that most of the societies are following this as a process, is to lay out all the good offers which are matching the tender pertaining eligibility criteria before general body, that is all the members, by inviting those members to be part of such meeting by following a proper due process of issuing notice to members 7 or 14 days prior to the supposed date on which this discussion will be taking place as per their bylaws, explaining each offer if possible in a comparative chart form so that you can get to see the area part which developer has given what, the compensation part which developer is given what, the date of completion part which developer is proposing what, the bank guarantee, the collateral, the track record, the number of experience, the number of project, number of square footage developed part, all those things we need to put in comparative chart for society to understand. And then
But do they do that in reality?
most of the
The comparative
societies,
analysis, they do
if
that?
you have good PMC, he will do it for you.
Right.
That is his job. And it is the way in which you can address 30, 40, 50 members or 100 members at a times in short period of time by circulating that document along with the agenda of the meeting so that everyone comes prepared.
Right.
So it's not a surprise. And in that scenario, then the voting needs to be taken, and then you have to kind of shortlist the best offer as per the majority's opinion. After deliberating and debating on what are the best points with the offer, what are the concerns of this offer, and if at all the good points which are there, despite that there are some concerns, then holding that decision for that day, deferring that decision for other day, and asking the developer to be part of such meetings, or sending your committee's representative to developer to get your concerns addressed, and asking for the developer to give us clarity on those open points or things which are not clear for you to take a conclusive decision on this topic. Involving everyone in this process is a critical thing. Members should not give right to appoint developer to managing committee under any kind of resolution or any kind of authority. It is a general body decision that has to be taken with 51% consent again. And taking this as a mindful decision is utmost important, because society members should remember that that decision is going to define not only next 3-4 years pertaining redevelopment work and process and project completion, but also is going to give them a house that they are going to
Absolutely.
stay for next 30-40 years. Probably their next generation, for which the society members are doing, are going to either enjoy or are going to suffer.
100%. In
So
fact, I feel a redevelopment project going wrong is the worst. It's even worse than a normal project going wrong, because in a normal project, at least you have your house, right? Assuming you have one house and you want to buy a primary
another,
apartment and
yes,
that gets stuck. But here they've broken your existing house and then got it stuck. So that could be kind of, double
I
whammy.
I call it, it's like your own business partner not giving, despite you contributing your side of it, and now you are waiting for business partner to contribute.
Absolutely.
That's why in RERA, societies is not just a allotee or some flat owner or some other party. They are equated as a co-promoter.
Absolutely.
Now, in this redevelopment transaction, this one co-promoter is entering into a transaction which it does once in 40 years, 50 years,
Right.
wherein the other co-promoter, who has to deliver later most of the part of the
Right.
obligation,
Right.
is doing these kind of transaction every year at least 3-4 times, or some
Correct.
developers will do it slightly more
Way
or
more
lesser.
seasoned.
So they are looking at it on a daily basis, and this co-promoter society
Once
is,
in a lifetime.
so you have to be 10 times more cautious.
Now, speaking of caution, right? What all clauses should you have in the redevelopment agreement?
So it's a long list, Mayank. When we have to look at redevelopment
Sure, but
agreement,
just some few
absolutely,
non-negotiables.
absolutely. I'll definitely highlight few things. The redevelopment agreement is all about determining what developer is going to give you at the conclusion of the project. It's going to be literally like a Bible for you. Anything that arises as a problem has to have a solution in the redevelopment agreement.
Right.
So what are the offers that were given to you at the time of selection of developer needs to be brought in clearly in your redevelopment agreement. So that is what society is going to get in form of constructed portion, and also in the form of component in the cash component part, like corpus we say, and also the transit rent component part also. These things should be crystal clear. If there is delay and if there is non payment or non compliance of these offered thing, what is the time frame for which it can give some extension to developer, that also needs to be mentioned. And what if that extended period is also not in which developer fulfills those things, then what is the consequence of that, it needs to be also explained clearly. In the same redevelopment agreement, the developer needs to make appropriate representations as to his prior experience, his accountability, his genuine intention to undertake this project and complete it from time to time, phase wise, or from time to time as per the layout that he has put forth and approved. He will stick to the plans, he will complete the project and keep society informed about everything. He will not deviate from the plan as per RERA obligations, RERA related undertakings and obligations, and society's obligation also, that anything that he collects for this project will be used in this project only for all the development activities that he's supposed to undertake and promotional and marketing activities that he's supposed to do to sell this project effectively. The clauses should also put restriction on developer on the part of if developer is trying to change anything, it needs to have a prior consent and permission of society members after giving them due prior indication,
Is the
information.
same two-third consent there? The same
No,
as
it will determine majority consent from the society members, and managing committee's rights will also come in. But it has to be a general body 51%
Acha,
consent
then
again to
okay,
go
got it.
about it. Depending on how severe or how major deviation is in the proposed project, some sort of challenges if developer is experiencing, what would be the consequential scenario for society to deal with if it's external factors that developer is dealing with. Suppose like COVID thing happens and there are no labors, so there is no workforce. Now, how do you expect developer to put more floors? So for such scenarios, what would be the treatment?
Unforeseen force measure will
Force measure we
right.
call it in legal terms. So whether developer will be still liable to pay you rent in those time frame, whether the delay will get questioned afterwards, whether there is a win-win scenario or amicable scenario that to be drawn up, many things will come into effect. There will be also critical clauses like if developer companies dragged into some sort of litigation outside the project, but it has an impact on this project, what would be the consequence in the project, and whether that will give society a right to get rid of that developer, terminate the project, take it back in their own hands, kind of thing will also come in. Many a times you also see developer getting into redevelopment agreement in this project, and then suddenly the management will change, the stakeholder in the developer's company may also change. So is developer literally selling your project to different individuals who are going to enter into this project by entering into developer's company,
Right.
restricting that also? At no point in time the original partners and shareholders or directors of the company who came in as a developer should leave the project or should leave that company before completion of project, or it will be at the consent of society members. All those clauses should be coming in. Another crucial clause, Mank, is ability of developer to pledge the undeveloped free sale components with banks to raise funds. So basically, their developer is mortgaging the development rights with the bank
Essentially.
to raise funds. So that also needs to be done in a manner that clauses should be structured in such a way that developer is not having unrestricted right to raise money. It should
Right.
be only restricted to the free sale component. It should nowhere put charge on the rehab components area to go about it. Clarity about parking, clarity about amenity, clarity about components that are going to go into your apartment, right from fit outs, right from electronics, or plumbing related specification, tiles related specification. If you're going to have a gym, describing the company's equipment that you're going to have in gym. So to the T,
All the specifications.
specification needs to brought in. It can go into annexure forms. It can go into many supplementary documents with photos, with specification, with color combinations. You can also determine what will be the name of the building after completion. Sometimes developers will modify that. Sometimes societies are very committed and united on retaining their original name also. So determining that part will also come in. Another important point is, suppose there is a dispute ultimately that you are encountering, how that dispute will be handled. Not all the redevelopment agreements we get to draft or get to see would force parties to directly jump into court. There are ways in which you can handle a dispute. First, identify whether it is a dispute or not. Then there can be a mediation clause where parties will get into mediation process where without going to court, they'll try to resolve it internally by having a third party mediator coming in. If that is failing, then you can choose alternate dispute resolution method, that is arbitration, which is similar to
Right.
court, but it is done in a private setup without announcing it to the entire world that you are in dispute.
And not to burden the Indian judicial system that is already so overburdened.
Yes, or to get stuck into the
Right.
long queue
Right.
of court matters. Uh, how to constitute that arbitration tribunal, pertaining clauses will also come. What will be the cost structure sharing on that will also come. What is the rules and regulation that will apply that will also come in that clause. Right to amend that agreement will also come. Right to determine whether the parties are looking for this project completion will continue to be held accountable. Sometimes developers are called in to furnish bank guarantee. Sometimes developers are also called in to put collaterals, not of the same project, but something which is completed in nature.
Right.
We have seen some societies making it a clear demand right from the tender document form that if you're putting up offer, you also will have to be ready to put a constructed component as a collateral, where society's charge will be created on developers some other project pertaining constructed component,
Right.
and with phase wise they will release that charge. So if the project is completed 50%, 50% of that collateral will stand released. As and when it reaches to 100%, it will reach to 100%. And if there is a delay beyond a agreed time frame, then society will have right to take that collateral in hand or sell it and raise money and take up the project by terminating the agreement and start balance work pertaining construction activity. So many of these clauses are important to be captured. The critical clause that you and I were discussing earlier also on the GST part.
Million
I'm not
dollar question.
I'm not chartered accountant, Mayank, so I may not be the best person to give you my thoughts on who should be rightfully entitled to pay GST or supposed to pay GST as a duty, but your agreements also can determine that. So if society puts that obligation straight away in clear black and white terms on developer that in this project any and every GST liability that is going to be arising out of any kind of transaction that we are doing, it will be developer's responsibility, then it will be developer's responsibility ultimately. So these sort of long list of clauses, Mayank, that society has to think it through, discuss it with PMC, discuss it with lawyer, have their chartered accountants inputs also, get all the members together on this right from initial draft discussion till signing.
Right.
All of them should be kept informed. And I would also recommend strongly the process that society with multiple members, majorly when the members are beyond 20, 30, it should be done in a very, very transparent manner so that every clause is explained to society members what they are signing at. And if possible, that should also be recorded in some way so that it is always handy for society members to revisit what they signed up for. This will set the right tone for the redevelopment project that is going to kickstart after signing of that redevelopment agreement, which again I'll say is going to be the Bible, it's going to be the Gita, it's going to be the guiding book for entire redevelopment project.
And this redevelopment agreement will be duly registered and stamp duty will be paid for,
Precise.
right?
Yes.
Now, how will you calculate the stamp duty? How will you ascertain that 6% say, right? On what value will you calculate that, say, stamp duty here in Mumbai is 6%? So, how will you calculate the value on which you incur the 6% stamp duty?
The project is going to have certain turnover. The project is going to have certain construction and handing over of certain apartments. All of that gets valued. All of that will find its place in redevelopment agreement in terms of rent compensation, in terms of corpus, in terms of square foot that is going to be sold or that is going to be handed over as a part and parcel of redevelopment. But that will also have a fiscal value, that will be also have a ready reckoner value, that will have also have its market value. All of these costs are adjudicated by the stamp duty collector. So typically whenever a redevelopment agreement is finalized, it doesn't directly get registered. It is taken by licensing agents with registrar's office to a registrar's office for adjudication.
Right.
It will be looked at, it will be reviewed, it will be studied. All the components and aspects of the agreements will be checked to see to it that what all things are having commercial value attached to it. And that value will be computed as a transaction value for the exchange of development rights.
Right.
And that computation and that total value, let's say 500 crores is coming as a total value, on that there will be a stamp duty will be charged to developer if they are taking that onus on themselves to pay to go about it, which is a normal norm in the practice.
And this will not include the component that is out there for sale
At the redevelopment stage, no.
at the redevelopment stage.
No, because if you or I are buying any project pertaining apartment, which is part and parcel of a redevelopment project, for us there is a separate transaction taking place
So
at the
there'll be
stage
a
of
double stamp duty then for no
that.
reason.
At that stage, man, we'll be entering into separate agreement for sale. At that time, we will be paying stamp duty qua our apartment only for that unit that you or I are going to buy. So
Right.
that time there is a different collection of stamp duty that is happening for free sale component.
Right.
But this was a joint project that society and developer entered into, which was captured in a redevelopment agreement, which has all the elements explained, which has commercial value. So that's easy to quantify in one go, and that is it. Now, whether PAAA needs to be stamped again, definitely yes. As a normal instrument, it needs to be registered and has a nominal stamp value. But if any rehab member is buying any additional surplus area over and above that he or she is receiving in an ordinary course of redevelopment project that others are receiving in the same project, for that additional area, there can be a condition that developer put that stamp duty for that additional area, the member will pay, which is again practice in market to go about.
Right. And I think one big thing, like we discussed, GST is still ambiguous, right? If you're not putting that in the redevelopment agreement, whose responsibility or liability the GST payment is, generally, can we assume if it's not written in the redevelopment agreement, the member is going to end up paying the GST to the developer?
I would say, man, when you and I subscribe to any service, we are receiving service. And if someone is offering that service, that GST burden is passed on to us
Right.
to go about paying. We are subscribing to a service. Similarly, if a free sale component buyer is buying an apartment which is under construction, there is a GST component that the same free sale buyer is going to pay. Similar to that, in my limited knowledge on GST tax aspect, but I say that since society has not expressly mentioned in the redevelopment agreement, society is taking service of developer, it will be passed on to society as a burden till the time there is no clear final adjudication and judgment or clear law that is given in any code or clear directive principle that comes in any kind of notification. It will be passed on as a burden to society to discharge.
Okay, now for our viewers, right, can you tell us what is the bank guarantee that the developer is supposed to give, in the redevelopment process? And is it more important than the post-dated rental checks a developer would give to the tenants, to the members?
So, in a redevelopment agreement, whether society should expect bank guarantee or not, answer to that is positive yes, they have to. 79A directive principle strongly puts it, expressly puts it in the list of obligations that developer has to undertake, and society is right to demand that is very much. Now, question remains is what is the quantum of bank guarantee that society should expect in a project of redevelopment? Because bank guarantee means it's not just the undertaking. Developer literally has to make a provision of that much amount that will sit in some account, which is something as an accessible account for society to be called in when there
Right.
is a default on obligations that developer has
Right.
offered you as an arrangement. We have seen, and this is to be confirmed by project management consultants also from time to time, that 20% to 30% of the construction cost, not the project cost, of the construction cost is somewhat bank guarantee that is expected to be provided by the developers to society.
Right.
Some component is also considered towards the rental payment, the transit rent or the temporary rent compensation part that is coming in. It is also to have some level of access to a quantum or to the sum if at all developers commits any default in doing the timely payments to the members. That brings me to the second part of your question about checks. What we have seen in a scenario where developers would make 12 months pertaining payment arrangements in society's favor, and for the remaining time of projects there is a bank guarantee component will also be coming in. So your default of rental payment would also kick in a default which can also connect to revocation of bank guarantee. If
Right.
you design your redevelopment agreement, it can work in that scenario also. Very rarely societies end up negotiating for this and end up getting this, but it is possible and we strongly recommend that. Many a times developers also try to coordinate and do the direct payment to society members rather than routing it through society's account.
Hmm.
Sometimes members have their need, they are having
Hmm.
this is seen typically in low income group
Hmm.
societies where developers and societies end up agreeing that direct payments will be given to society members or checks will be handed over in advance to go about it. Whatever majority confirms and approves is the modus operandi or method that they can go about adopting. But is it a good practice to have post-dated checks only? Not necessary. Your agreement is also going to be there, and where one society member is going to start chasing developer for one each default, if at all there is a problem
Right.
on making of payment and testing whether developer's account has sufficient money for their component or not. So I think when there is a sufficient bank guarantee taken, uh, that could serve as a good
Right.
backup mechanism, and that will also keep developer on toes, because for small default of not paying rent also he can end up losing that big sum
Right.
to go about.
Now, what approvals should a society make sure the developer has procured before they end up vacating the building before demolition?
So it's slightly simpler process that developer has to undertake. Basis of the redevelopment agreement and using the power of attorney, developer has to get necessary building plan and sanctions from municipal authorities, or if it's a MHADA layout, MHADA authority, if it's a SRA project kind of thing, then from SRA authorities on the finalization of the plans that were proposed to society,
Right.
and basis of which society enter into redevelopment agreement. And the initiation point is to get a intimation of intimation of disapproval, which is a list of all the minimum required things that developer has to do to kickstart the project by getting a commencement certificate. So from intimation to commencement certificate pertaining procedural license that developer gets, most of the times at this stage societies vacate. Once this IOD is provided to society as a reference and record, and the first set of payment that is agreed for rental and some corpus component payment that is agreed in the redevelopment agreement, when all these things are furnished, then societies should vacate if it is in agreed terms.
Is there any thumb rule for this corpus?
It is completely commercial call, man, because some societies will get more area and lesser corpus
Hmm.
compensation. Some societies will have lesser area but more
And more
corpus.
corpus.
So it relates to what is the true potential of area and how much society members are willing to let go in lieu of money.
Understood.
And sometimes some pending dues, some charges of water, taxes, all those things will also come in as a need for society to get access to some liquid funds. If societies are not having enough money saved, accumulated, and if society wants to build their sinkage fund, if they want to build their war chest or reserve funds, if they want to keep enough money with them, so when the new buyers are going to come in, they are going to contribute some money, so they need to have something at par so that contribution should match for future scenario. For all those things developers may justify, and society should get cross check with the lawyers and PMCs whether such arrangements of funds makes more sense for them, rather than taking everything in area and very less in cash component. Should they go for a healthy balance, or rather than taking everything in cash and not taking enough in area, so that they will still stuck in the same size or not so bigger size of apartment and deal with same scarcity of land and limited area pertaining scenario, which is the best combination that
Yeah,
they should
you
go
outweigh
about.
both the options and you.
Yes. So for that, CA also will play a very important role on financial arrangement part, who will help them in understanding the tax implication also of all the things that society is going to receive.
Yeah.
Lawyer will also make them understand that what is safer scenario for them, although it's more pure commercial and technical call, but documenting that and helping them to understand what is more enforceable and PMC will also give them clarity which is more doable act from developer in all scenarios to go about.
Right. Now let's talk about the PAAA, right? A, how important is the PAAA, which you've briefly covered in the first question. Two is the non-negotiable clauses, the important clauses members individually need in their PAAA. And third is at what time will you register this?
I would like to start in the reverse order, Mayank,
Let's do
because
it.
that is the crucial thing. Signing of PAAA never should be left towards the end of project completion, which is unfortunately we get to see many a times. Signing, execution, and registration. This all together should happen. Sometimes only signing happens, but registration and stamp duty payment doesn't happen till OC is to be applied for. So first of all, before you hand over your old tenement's position, you should have a registered PAAA with you. That is first and foremost. Second, who should be parties to PAAA? You being a member of a old society which is giving its component, you have to sign that. Developer being the promiser who is going to give you new component has to sign that. And all of this is happening in the outfit of society. And society tomorrow should not have any objections or any concerns on what arrangement that you and developer ended up having was not in accordance with some redevelopment agreement that society was trying to get
Right.
implementation and compliance of. So these three stakeholders need to sign it. What is the critical components of the PAAA agreements is ensuring that the area description, location, size of the apartment, what is coming with that apartment as a alternate accommodation to this member in the supposed newly constructed building. So description of the unit has to come in absolute clear terms. It should also indicate that what kind of temporary alternate accommodation, temporary rent the developer is going to give to this member should also be mentioned very clearly. It should also give very clear reference of redevelopment agreement and should make express governments to say that everything that is mentioned in the redevelopment agreement will apply to this PAAA agreement, and termination of redevelopment agreement will also amount to termination of PAAA, because if the redevelopment agreement, that is a mother document, is terminated, developer should not enforce single PAAA agreements to go about. It will also give reference of all the critical changes that if at all developer is going to do. For that, the PAAA agreement will also go under modification. So any change in redevelopment agreement will also call for amendments in PAAA agreements.
Right.
PAAA agreements will serve as a title document in lieu of the earlier original document.
Right.
So if suppose I was a member who had bought an apartment in 1990s and now it is going into redevelopment and now I am entering into PAAA. So my PAAA agreement also should explain some brief details about my 1990s transactions so that there is a continuity.
Right.
That in 1990 Rahul Hingmire purchased that apartment, and in 2025 that same building went under redevelopment, and in that redevelopment process this PAAA was drawn up as a document which will serve as a title document. So any new buyer who will buy this property, suppose in 2030 from me, he will have clarity as to how this PAAA document came into existence. What is the reason that from old transaction we are jumping into redevelopment and the new unit, and how old unit is connected to this new unit, and this
Right.
new unit is independently owned by me. All these things needs to be brought in, and again it needs to be signed, stamped, registered. It needs to be done in such a way that it has no ambiguous terms and conditions, and it is coterminous with the
Right.
redevelopment agreement.
Right. Now, any tips or tricks for society members who are redeveloping the society? Any tips or tricks for them on how to negotiate for additional area with the developer?
A strong recommendation is to have PMC on your side through and through, and try to be more vigilant and alert on not only what developer is doing, but also all the changes that are taking place in government rules and regulations. You should also have an important clause in redevelopment agreement which should say that any change in rules and regulations, and that change resulting into any new additional FSI or development potential getting generated on that plot, that additional potential should be either taken by society, that is one very favorable clause for society, or that should be equally shared between developer and society. That is another smart way to protect and generate more additional area or development potential if there is a change in law that is happening in future. Societies assume that anything that is generated in future naturally belongs to them. It's not the correct thing. Sometimes there will be a lot of restriction. Sometimes it will require cost of procuring that additional premium or new FSI also. So all that needs to be mentioned very clearly. If developer is delaying the period possession date, at that time also society can explore in having some understanding that instead of cost component they would like to have more area component to go about it. Not everything needs to translate into money, because developer, if he is sitting on a large scale development potential, probably it will be easy for him to share some area instead of cash component. That will not affect his cash flow, which is very critical thing for him to continue to pump in money in the project to construct and market and sell the project to again generate more funds to complete the entire activity of construction, which is a capital intensive thing to go about. So these are some ways in which societies can use situations changes to their advantage, and for all of these things society needs to be very balanced in their approach, needs to have a constant interaction with their project management consultant and lawyers, and also to monitor the activities that developer is doing in different projects, also to understand what is the developer's situation is like, if they are getting dragged into some legal cases, if they are going to require some support and assistance of this society, some accommodation on timelines. In all these scenarios society can make an interesting play for themselves, and probably you never know, developer may give some additional area for this.
Now in a society redevelopment project, when it's going for the entire structure is going to redevelopment and that gets delayed, right? What legal remedy do the society members have? Because technically they're not allottees as per RERA, right? So what recourse do they have?
Very right point, Mayank, you mentioned. Societies are not allottees under RERA, because of which RERA code doesn't help them as it would help the free sale buyers. So, societies members who are party to redevelopment agreement are left to find the recourse in their redevelopment agreement.
Right.
The redevelopment agreement needs to give treatment to this default also, and will that default will result into additional penalty, or would that default, which if it is continuous in nature for 6 months, 12 months, or some period that is mentioned very expressly, would result into breach of agreement, and would that breach is curable breach or fatal breach,
Hmm.
and would that breach will result into direct termination of redevelopment agreement, or it is a operational termination, like one member will society will have to send a termination notice. Is it an automatic termination of fulfilling this duty, or it is a manual termination notice that needs to be served after society members coming together and coming to a conclusion that this developer is not following its duties of completing projects on time bound or making necessary payments on timely manners to go about. So these delays or defaults will find its consequential treatment that society has to adopt and give to developer in the redevelopment agreement. And naturally termination is a step which is very crucial in redevelopment project, which developer is not going to be happily accepted. So there will be a consequential dispute resolution method. So Mayank, suppose I am the society and you are the developer, and for some reason I am of the opinion that you have not done what you promised under the redevelopment agreement, and I issued termination notice. So that is my decision to terminate.
Right.
Now you have a choice to accept it or you have a choice to contest it. Where do you contest this? In the dispute resolution method, that is before the arbitrator. And for that you will either appoint an arbitrator or you will go to High Court to get an appointment done to start that arbitration. And in that arbitration you will question my decision. So till the time you don't take this step, my notice of termination is considered as a termination of arrangement between us, unless arbitrator or a court sets it aside and says nothing doing, arbitration will take its own course. But till
Hmm.
that time, project has to continue. Or the same court or arbitrator can take a decision saying that it is a valid termination and developer should first cure the breach to find any reason to contest, or developer should simply put the claims of damages because society has taken a call and you have been validly terminated. Whether their decision of termination good or bad, that will trial will decide. That is a long process of filing evidence, cross examination of witnesses, and final decision of the court. But in the meantime, whether society has a free right to appoint new developer or not, that will also come as a decision from the court to go about it. So in this case, Mayank, you as a developer will challenge that order somewhere in
Of
higher
course,
court
and
to restrict my right to go about appointing new developer to protect what you have invested in.
but let's talk about, say, claiming damages for that particular delay. How is that ascertained?
Of quantifiable terms will help
Yes.
in quantifying the damages. What is the cost that society has suffered? Or, for example, again, let's play the same role, Mank. I'm the developer, you are the society. I'm not making timely payments because of which you are being deprived
Right.
with that money part that is coming to you. So claiming damages for the delay or non-payment of money part is the principal amount that was come to you along with some reasonable interest that you would have otherwise received or you would have made on the original money that you had to put in this cost. So generally, if there is a delay in making payment, the offers that get exchanged between society and developers are like around 10 or 12% interest. I will put that I kind of I may have made by not paying you timely, or society has lost as a loss of opportunity by putting the money that they were not supposed to put in their own rental payment or late payment on the corpus part to go about it. So these kind of methods are certain. uh, there are many judgments, there are many situations that courts and arbiters have seen in this scenario. So quantification is not a very complex thing on the ascertaining the payment obligation pertaining damages. Now, bigger complex part is non-compliance on construction.
Hmm.
Suppose again you are as a society, I as a developer, I have never started the project after taking possession from you. So for you, claiming damages is a secondary. For you to kick me out from project is primary target and
Yeah.
objective.
And
And
that's also the bigger threat for the developer, right?
yes, and then the damages will be as a claim that I may bring on you because
Right.
I will say, look, I paid you, that's why you vacated. I entered into so many documentation which required so much of stamp duty. I paid all that. I have got approvals. I have taken so many permissions that also needed premiums and payments. I cleared your water taxes. I cleared your BMC. I helped you during monsoon period by putting some safety measures. I have given you more than what I required as a compensation of corpus funds first installment payment. In this scenario, even if I have not started some work, still I am entitled to receive my entire money back if you have decided to terminate and I am not interested in pursuing your project. So situation like this, Mayank, for you will be to get a developer who is willing to absorb that cost also in his proposed project for you,
Right.
and that is when you will be able to deal with my claims. Eventually court will have to determine what is the correct amount. I will give inflated amounts most of the times. You will have to negate that, dispute that, and bring it down to the actual assertable amount only, and probably with some 10-12% interest you may have to pay me the amount that I legitimately paid on your behalf.
Right. Now you've spoken primarily about cooperative housing society redevelopment, right? Can we talk about the Pagdi buildings? How much more different is that than this?
In housing society it's a majority call, right? In Pagdi it's the owner's call. It's
Landlord.
the landlord who will call the first shot. And landlord's relationship with tenants, because of which tenants will get an offer because they are protected under Pagdi Tenancy Rent Control Act provisions. So the developer cannot just negotiate only with landlord. Developer will also have to strike a deal with the tenants.
Absolutely.
The mega change that happens is post redevelopment of Pagdi tenanted properties, the tenant doesn't remain tenant after that. The tenant receives an alternate accommodation for which the tenant becomes rightful owner. Now, because of this, the landlord, suppose landlord is not in possession of any premises, so landlord gets one component of the land value, of the structure value. At the same time, the tenant gets a value of its tenancy rights, that he or she was protected under Rent Control Act. So the components that under redevelopment of a pagdi tenanted building would be in two different segments that will be flowing. One component towards landlord and second components towards the tenant. It could be money and premises, it could be premises and money, it can be both money, or it could be both premises. Combinations of many things work as per the commercial negotiation and the location where the property is going to come up.
Can you tell me about some common scams that you have come across or that you are aware of in the entire redevelopment process, primarily from coming across from the developers?
Mayank, there are many situations, unfortunately, that our High Court and some city civil courts are flooded with the matters which are nothing but result of these kind of scams. Some developers, and I'm sure many other developers will also agree with this, that some of the so-called developers, but they are merely some, business companies who are trying to claim that they are developer, are in the scheme of blocking the societies. They will enter into somewhat one-sided redevelopment agreement. They'll put some amount of money in the deposit of accounts of society under the caption of first payment or corpus payment, but they will never take the actual step of commencing the redevelopment
Hmm.
under guise of some challenge within the society's record, under some challenge of society not having NOCs of some authorities, or not having clear record, or delaying or deferring the approval part, or supplying and taking confirmation from the municipal corporation for next phase of work part. They will sit on that project purely because they were never competent enough to take up such project financially, or with experience, or with know-how, or with the strength that generally good developers are equipped with. And they wait for society to lose their patience and terminate the agreement. And when the new developer is about to enter, they will start filing litigation against society.
Hmm.
And trust me, these kind of developers, those who are sitting on development rights pertaining agreements but not taking steps, they will not do this with only one society. This is their modus operandi, and they will do it with multiple societies. So it's very easy to spot them, and once happen to see their one project pertaining modus operandi, it's very easy to kind of connect the dots with their other projects also to go about it. This is one thing that developers generally get into a project without having intentions to complete it, and this is a very routine thing that we have seen from some of the developers who are yet to finish their first 2 3 buildings also, but they are sitting with 13 14 15 development agreements and rights with
My
them.
God.
And
My
I
God.
have seen cases where people have given up, gave the societies have gave development rights only against the payment of 1 lakh. That would not be even 1/10 of the cost of their one unit.
My God.
But they went with some name, some presentation, some a local politician coming in and influencing their decisions and things like that. So
It
it
almost seems like organized crime.
it's a well thought, conspiracy, you can, so well planned, well executed conspiracy, till the time society loses its patience and decides to bring new developer, and then they start their actual phase 2 of the operation, that is
Right.
to stop, block, and then try to settle with the new developer at some amount. So their original investment amount plus some amount that will get them doing. And who is paying for this amount directly, indirectly? Society.
Society members.
Because the new developer will also ask society to adjust it from his own account. Why would the new developer pay for this kind of problem? So this is one type of scam that we always get to see. Second, developers will take one project with hopes that they will end up making bigger project, or they'll try to do TDR schemes, they'll build more area, and then when they know that there is no enough development potential available in that one single plot, despite that they'll offer something greater, but purely with the hopes that some schemes that are in pipeline or some neighboring plots that are not right now currently interested but will become interested in near future, and basis of that they'll keep the project stuck at some initial level, because of which societies again will have to helplessly wait for them, because the kind of documentation sometimes these societies will drop by leaving entire process of drafting and finalizing agreements to developer and developer appointed lawyer. They cut their own hands in some way,
Hmm.
and then they helplessly leave their future at the mercy of the developer to go about it.
Now you've spoken of developers, right? What about committee members? Have you seen sometimes committee members trying to influence the other members just because the developers probably bribed them, or they want a way to go, they want things to go in a certain way?
Unfortunately, many times, Mayank,
Many
many
times.
times,
Okay, so
uh,
not sometimes, many times.
many times, if the see, why would society involve lawyer when there is a problem? In a society, post redevelopment agreement, if they have to still come back to lawyer to narrate something, that means things are not materializing or not taking place as per their expectations. When societies have to change developers, that means something is not happening as per the expectations. When projects don't take off effectively after the redevelopment agreements, that means something is not happening as per the promises and representation that were given to you. Now, committee members who are elected by all the members to be part of managing committee, and then managing committee can sometimes create a redevelopment committee, or managing committee can drive all these things on their own. They get to become the mouthpiece of society members, and they become the voice, and they become the bridge between society members and developer. They try to receive information, and then probably they will filter it and release relevant information. Sometimes it is done with good intentions, sometimes it is done for trying to find an opportunity for themselves to make something out of it. And despite knowing the fact that some decisions are going to cost time or money of society members, still they will pursue the members to go for such decisions. They play with emotion because they are closer to members, they know what chord will strike what, and they try to use that card again and again to go about it. Some of the members are also having backing of some political parties, so those influences can also be determining factor for members to say yes to all the calls that these managing committee members are taking. Some of the managing committee members are having track record and history of taking police assistance, filing cases, and damaging the reputation of societies by putting allegation or questioning against some developers or sometimes some members. So some members in city like Mumbai are not all of them are ready to have all these kind of experiences. People are already having 9 to 6 job which requires 2 hours one way traveling also. After
Hmm.
all that, where do you think the energies will be to deal with this kind of nonsensical scenarios? So some situations will allow managing committee members to take advantage of other members ongoing circumstances and scenarios to go about it. And we have seen sometimes developer influence these committee members. They promise something, they give certain amounts, or they may give some additional area, and they give some additional parking and additional terrace or this and that, till the time it is working out well for developers. But very few developers are in this kind of practice, Mike, because all these things get seen by PMC. All these things can get noticed by lawyer and chartered accountants also. So it requires great level of risk taking ability by developer to do all these things for society members. But managing committee may having society members of all types is a matter of routine. In every committee, Mayank, I personally think my experience has been you'll have 33% members who are always taking great steps to protect interest of society members. You'll have most of the times 20 to 30% members who are not bothered about majorities of interest, but they are trying to look at something in that moment for themselves or something which they don't have vision for. And the remaining members, they are clueless.
Right.
They are
I
just
I think a
following.
majority of them are just
They
clueless.
are
Yeah.
just following
Right.
some more force. They are following someone with more command and standing and more administrative control of that society. They just follow them, their lead.
Right.
So having good PMC and having good lawyer and CA would help even society members who are not in charge of or who are not leaving everything to managing committee would take back the control in some way. And if at all you see corrupt managing committee members, law is not silent. You complain it to a deputy registrar and you highlight their inactions or wrong actions or violations. uh, Society will be, managing committee members will be called upon. I have seen a scenarios where jugglery in accounts and mishandling of funds have also resulted into criminal cases against managing committee members. They are not protected under any law for criminal actions or ill motive pertaining actions. And administrator can get appointed on society's managing committee and society's affairs till the time things are not resolved. So
Right.
anytime you come across such nuisance or managing committee members who are trying to misuse the power that has been vested because they are office bearers, there are enough provisions in law to get rid of that scenario and turn that into again a proper situation for larger interests of society members.
Right. Now, from a developer's perspective, right? Let's talk for once for a developer's perspective. What, according to you, is a developer's biggest expense in a redevelopment project?
My cost of construction will always be the biggest expense nowadays. My understanding from what I get to hear, if it's a redevelopment, that means developer is not investing money in buying the land, but
Correct.
he's putting money in buying the development rights. Sometimes that, or most of the times, the cost of construction remains the highest investment or expense we can call it. After that, developers, if it's in some of the new projects that he is doing, then he will have to invest heavy on marketing. But if a developer is having an excellent track record, especially completion pertaining record, and he has done good amount of projects in the vicinity or in city, then probably lesser marketing and more pull he will able to generate, where people will come and put in money. The cost that is not an expense but gets blocked for developer is the money in bank guarantee when he is entering into redevelopment agreement.
Absolutely.
That gets blocked. And
Utmost
also,
blockage of cash flows.
yes, and second, even in the RERA, he's supposed to put 70% of his cost of construction in a RERA escrow account also.
Right.
So these two things will always put a great deal of burden on developer in terms of putting a substantial amount of money under a reserve kind of mechanism, that is as a backup of failure of developers to do the needful as per his proposed timelines to RERA as well as to the society to go about it. Rest of the things are manageable, and I personally think, man, real estate, if it's done properly with full transparency and with honest intention, apart from first 15 to 20% of the money that is needed upfront, rest of the entire thing developer can generate from that project, utilize for that project, and still take substantial amount from that project as a profit to go
Right.
about it.
But there's a lot of stress and jugglery involved as well. Like my developer friends keep telling me how expensive rent is
Yeah.
in Mumbai. For a society which you're redeveloping in South Mumbai, the rent alone is substantial that you'll be paying to the members. Now, why is it that I am theoretically a fan of cluster redevelopment, right? I think eventually it'll make a better master layout for what comes out, right, if done well. But why hasn't cluster redevelopment, according to you, been that successful so far in Mumbai?
Mayank, I want to give slight angle on the jugglery or the juggling part for developer first. My one take is construction business in place like Mumbai, Pune, Thane is no longer about knowing how to construct building. It is now more to do with people management,
110%.
cash flow
How many
management.
developers construct their own buildings?
Yes,
Barely.
yes. So they are managing people, managing cash flows, managing expectations, managing uncertain circumstances.
I think a developer is getting highly paid for the stress managing ability.
That's where I was going to come. So they are
so
getting paid for that. which they
Absolutely.
signed up for.
Yeah.
And they have outsourced the construction part to someone who is going to be happy with some component or some barter system.
Absolutely.
So they are actually getting info to manage that stress from all sides.
100%. 100%.
Talking about the rent part, see, after COVID, the rental market has become unpredictable in different pockets of city like Mumbai, even in Pune, even in Thane. People are finding more and more value for convenience because most of them are leaving their homes selectively. So naturally, the more intake has increased after COVID. People have started realizing better houses is the need, and because of which areas like South Bombay, Lower Parel, in Central, in Sub Western, every property is demanding increment in rents, which was unimaginable compared to pre-COVID scenario. We used to see a steady 5 to 10% annual increment in these locations that you mentioned and I just narrated. After completion of your leave-in license or rental period, the jump is of 25% in rentals.
Right.
Now, how do you average that out?
Absolutely.
So PMCs are looking at those rental rates that are growing in markets substantially
In
compared
the
to.
last 5 years alone, data, I'm talking about the registered IGR data of leave-in license agreements, the rent has on a straight 2x. What a person would pay 80,000
Correct.
right now is paying minimum 1,60,000 for the same apartment.
Correct. Now,
Rents have doubled in just 5 years.
so that's so
And that'll be a
high.
product life cycle of a project also
Yeah,
for a
yeah.
developer.
So for that, developer also has to be okay with uh, having expectation of society members to have some sort of expectations of rental of that area in which he is putting up the project.
Right.
So if you are staying in Malabar Hill and if you are exiting from that project, why would you be okay with some other area pertaining rent? You will say, what is the rent in my next building? I'm
Absolutely.
moving there so that I can see my building every day, whether you're doing
And
my
that is what
project
you'll
or not.
rightfully demand. Yeah,
Yes.
absolutely.
And I would also expect you should match the same escalation pattern or trend that we have seen in last 3 years. Plus, give me an undertaking that if we bring better scenario, like if there is a higher thing, probably you'll have to take care of that part also.
Right.
So all these things comes in as a justified demands according to me. And again, I'll go back to my first part of the answer. Developer has signed up for the stress, which also include dealing with this moving expectations,
Right.
moving upward specifically in rental component part to go about.
And regarding the cluster redevelopment, why don't you think has it's not really taken off in Mumbai that much?
Cluster redevelopment is in city like Mumbai, when you are dealing with size of 4,000 square meter plus area, naturally you may not find most of times few societies or few owners of the property. It will be combination of multiple things. I must share something that we are dealing with right now in South Bombay for a client of ours. That cluster not only includes societies, family properties which are in disputes, trusts which are having some properties, temples there is for which there is no claimant and owner who's coming forward, and some properties which are now not able to be located. It is existing on property cards and on revenue records, but physical existence is not visible for us to find it out. So projects of this scale, which also require a lot of determination from developers side, which requires a lot of resources to come together with a lot of expertise on ground reality part on the how to manage the expectations, manage the commercial arrangements, manage the legalities around it, how to source papers, how to bring enough information record so that you should know with whom we are transacting. All these things are needed from developers point of view to put their skin in the game for cluster redevelopment part to go about it. And to top it up, all of this has to then put before high power committee for their approval. Then HPC will actually determine whether this is a fit case and have you got appropriate number of members from this cluster for with a positive yes to go with you. Now there are a lot of moving pieces in this. So it takes a lot of courage, it takes a lot of guts, and it requires a lot of preparation. And without having to say this, but decent financial support to commit yourself a cluster project, because each transaction will happen at different level. You cannot have a streamlined formula, one jacket formula for all of the
It's
transactions.
10x the work,
Yeah,
10x the money, 10x the expense, 10x
and
of
risk
convincing power,
also, and
everything.
10x the risk, because
Absolutely.
one guy who holds a component or key location pertaining thing, if that guy knows the value that he brings to project, is going to be a tough nut to crack to go
Right.
about it. So it has multiple angles to go about it. And having said that, Mumbai is going to experience larger scale of cluster redevelopment. They needed some Adanis to come and
Hmm.
kickstart. They needed some good projects to get open up. They needed some big names like Oberoy's and others to also look at redevelopment as a way to go about it. Otherwise, earlier redevelopment was only done by tier 2 and tier 3 developers. Now, tier 1 developers are making that plan, making that game more attractive. So soon we'll have a cluster-led redevelopment and projects of this size, 400, 8,000, 4,000, 8,000 square meters project coming in. You and I met at one event, and that same developers, Sugi developers, are also known to be doing much larger projects on cluster part to go about it. We are working with developers like Vaibhav Lakshmi, and they are doing fantastic work in South Bombay at a cluster project level. So I think dynamics are definitely going to become more and more favorable for developers to opt for cluster project, and as you said in the beginning, more benefits for everyone, all
Right.
stakeholders. So why not to go for it? It's just some level of knowledge and understanding and some case studies. If they are there will be more participation in that project scheme to go about.
Right. Now, Rahul, thank you so much for this enlightening session. I think for everyone and anyone in Mumbai, I'm sure everyone has once in their life thought about redeveloping the building, right? Because a lot of buildings are so old in Mumbai. And I think for everyone in Mumbai, this has been a super duper enlightening session on redevelopment. Rahul, it's great what you're doing in the educational space as well. I know you're a busy advocate and a busy, I can call you a self-employed professional, right?
Yes.
Busy with your actual work. And I really like your passion. You're going out of your way to even educate everyone else, right? And it requires commitment and time, right? You have to take out designated time from your busy schedule and educate people totally free of cost, right? That's what it is. Huge shout out to you for that. And in your endeavor, you also written a book, which is right here. I would like to just. This is the book, right? 54 legal secrets before you sign a redevelopment agreement. And I believe this is before you sign the agreement. And I believe a part two sequel is coming to after signing, which is
Ye- bef-
the real headache of execution, right?
Yes, I didn't want it
Wow.
to burden the readers with everything in one go, because sometimes redevelopment project is too much to take in.
Right.
So the advice that I got from my mentors and my seniors was to go for phase wise. As developers go for phase wise, as we as a lawyer will also go for phase wise work. The book
Right.
is also phase wise. It is from the
It's impossible to put so much information in one book.
So it is from the moment society members start talking about redevelopment till they actually sign a redevelopment agreement with the developer. And critical stages, critical aspects, and some of the case studies that myself and my real estate team from Mumbai and Pune offices that have dealt with advice, without giving direct references or names, but we have tried taking some learnings from that, and we have put in here for readers to analyze and see it from the different lens, rather than just submitting themselves to lawyers like us. Probably they can find a neutral source and handbook, and probably it will also empower them when they are participating in their next society meeting, next interaction with PMC,
Absolutely.
next interaction with their own lawyer, because I have given must to know or to do list for selecting PMC lawyers and developers also. So a lot of things will become clear to them, and that will give them more confidence to get into conversations and get the best thing out of themselves.
Right. Fantastic, guys. Just pointing this towards the camera so the viewers can just see this and just, read this book, upskill yourself, and make sure you don't get scammed in a particular redevelopment project, negotiate well with your developer. So win-win.
Also want to add one more thing, Mank. Along with this book, we are also conducting redevelopment roundtable discussions.
Right.
Once in a month in our Mumbai office and once in a month in our Pune office, where I am being, supported by my fellow real estate professionals, be it chartered accountants, be it project management consultant, be it valuers, be it social media influencers like you, who holds great knowledge of real estate transactions also. They are participating with 10 to 20 housing society members representatives coming in, and we are having a full-fledged discussions on every aspect of redevelopment, be it from legal to technical to marketing to positioning, and what are the do's and don'ts the society members have to be ready with in terms of knowledge, and we give them answers to on their queries that are troubling them before for them to take the next step in their redevelopment journey. So this redevelopment roundtable discussion is something that I encourage all the society members, those who are in that phase of taking decision, to be part of and join in. It's just couple of our sessions once in a month in our Mumbai and Pune office. More details I can give you as and when we decide the dates for this. The next Mumbai session is happening on 12 December and the next Pune session is happening on 6 December.
Lovely. Thank you so much for everything you're doing, and I had a great time.
Thank you, Mayank, for this great opportunity.
Thank you.
Thank you.